So what do we got this month cases?
Well, on that, it's a good segue. I always try to find the good segues. I've got motion to reopen cases out of the Ninth Circuit this week. The first is Fonseca-Fonseca v. Garland. And it's a really important decision in the motion to reopen world. Essentially, Mr. Fonseca-Fonseca, he's put into removal proceedings. He's got a deficient notice to appear. He probably became eligible for non-LPR cancellation of removal after the Pereira decision because the notice to appear probably cut off his 10 years. But then Pereira says that a deficient notice to appear does not cut off the 10 years. And then Chavez says that a notice of hearing can't save that. So the stop time rule never stopped. Mr. Fonseca, all these years later, totally has his 10 years. It seems like that's what happened. It wasn't so much about that in this case. I'm reading the tea leaves a bit. But what the board said is like, okay, fine. And you've produced this new hardship evidence showing that your children will suffer exceptional, extremely unusual hardship. But we don't think that it's that you've established a showing such that we should reopen your case. Even though you're now eligible for it, we're looking at it. We don't think that you've met your motion to reopen burden. But the motion to reopen burden is a prima facie showing. That's the burden. But what does that mean? That begs a question. And the two BIA decisions that are always competing, it's matter of Coelho and matter of Log. Matter of Coelho comes out a year or two before matter of Log. Matter of Coelho is like the always cited to decision that says motions to reopen are disfavored. You really got to, it's a high burden. It seems like what Coelho was saying. But in this decision, Fonseca, the Ninth Circuit is saying no. All of that from Coelho is dicta. Coelho was really about that the non-citizen didn't warrant relief as a matter of discretion, by the way, to tie that all back. That wasn't about what is the prima facie showing. Matter of Log is that. Matter of Log is what applies to the Ninth Circuit for motions to reopen. For everybody listening, that is what you should take away. Matter of Coelho, irrelevant, almost. Matter of Log is relevant. Matter of Coelho is relevant because you still got to include the application for the relief you want to apply for when you get your proceedings reopened. Gonna get to that in a second, by the way, in my next case. But matter of Log is the standard on the prima facie showing. And the standard is not that the new evidence would likely change the agency's determination. That's not the standard. That's what Coelho would have you believe. That it would likely change the determination if you reopened. A prima facie showing, and I want to get the language exactly, is that only a threshold showing of eligibility, a reasonable likelihood that the petitioner would prevail. It's a much lower standard, it seems, than a standard requiring that it would likely change the decision. So it's a big deal. And it's a bigger deal because in matter of Chen, published by the BIA recently, when the BIA had to admit that it needs to follow suit and recognize that these deficient NTAs can now make people eligible for non-LPR cancellation, the BIA, as I read it, essentially said, okay, you have grounds for reopening if you can show that an NTA was deficient and you would have been eligible for non-LPR cancellation but for it. But we're going to apply this really high standard about whether or not you're eligible for it. And this is Fonseca doesn't talk about matter of Chen, but I don't see how those two decisions are reconcilable. I mean, Fonseca is your best friend in the Ninth Circuit. If you're now trying to reopen because of a deficient NTA or really any reason to apply for new relief, it is a low bar. Prima facie eligibility is a low bar. And that's what people should take away.
Yeah, interesting. Good stuff.
Matter of Log wins. It's like a 30-year-old fight. I don't know why it's taken this long, but it happens.
Welcome to immigration. Yeah. slow moving. And then when it happens, it's just like the dam breaks sometimes.
Right. And so that's the big motion to reopen case. And this last month, these are the August cases, of course, for that kind of motion to reopen. But that's like all other kinds of relief, non-LPR cancellation, anything else that you want to apply for. By the way, what is prima facie showing for adjustment of status? Essentially that you have an approved visa petition and that you're not statutorily barred because of a conviction or something. That would be my argument.
Yeah.
Maybe a little bit on discretion, don't get me wrong, but like the prima facie showing is not like a whole case. At least that's what Fonseca-Fonseca would say.